Welcome, everyone. You're coming in, you're trickling in from all over the country, probably other countries. Welcome to our fourth in the third series of CCC webinars, free webinars on, this one is on immigration interpreting in a remote world, understanding immigration interpretation then and now. As you can see, it's Tamber Hilton, who actually was one of a team of webinar presenters a while back for us. She is amazing. I'll talk more about her in a minute. As you come in, and there's already hundreds of you, you'll see a poll now, and you can feel free to fill it in. The first question is where you're coming from. Where are you now? And the second question is, where do you interpret often? And feel free to fill in as many choices for that one as you wish. I want to thank you for attending. This is actually probably the most requested topic for webinar that CCC has ever had. We feel like we've picked the perfect presenter. I want to remind you that if you want to send a question for Q&A to the presenter for the Q&A time, the question and answer time, please use the Q&A function. If you just want to say hi and chat or let us know where you're from or anything else, if you would use the chat function, but unless you change the default settings, they will only go to us, the panelists. So you want to change the default to adjust it to all panelists and participants. Now, obviously, there is a lot to remote interpreting in general. In immigration interpreting, there are a few twists and turns because not a lot of it is remote. But the person who's going to be guiding you is Tamber Hilton, who is not only a federally court certified interpreter, she's also run the gamut in her experience. She'll talk a little bit more about her experience, but in just about every area of immigration. And she's working on completing a law degree and very specialized in immigration law. So you're in excellent hands. We suggest that you use gallery view if you want to see me when I come back, but I'm about to leave you, and I will be monitoring the question and answer, the Q&A. We will have a 90-minute webinar this time. Normally, all our webinars so far in this free webinar series have been 60 minutes. This one is an hour and a half, so please don't hesitate. We'll have more time for questions. I'm going to hand this over now to Tamber. I didn't know if you wanted me to mention the poll or if you'd like to take that over yourself, Tamber. The results are interesting.
Yeah, the results are interesting. It's really cool to see that we've got people from every continent. People are still voting, so I'll just give it another maybe 10 seconds as people are taking a look at that. But we've got, as we might expect, a majority of people from the United States, but we also have representation from Europe, Canada, Asia, Africa, 3 people in Africa, 5 in the Middle East, Latin America. So that's really exciting. Welcome, you guys, and thank you so much for coming.
Truly.
So I'm going to go ahead and just end it and flip it out so you all can see it. So that's the results. That's about all of you. So I'm so delighted to be able to present today, and a big thank you to Marjorie for having me back.
And I don't know if you wanted to share before I disappear where they interpret often, because that is fascinating as well, but I will leave you to that.
Yes, I just closed my window on that, but I was seeing that a lot of community interpreters, which, you know, that's where I started as an interpreter. So 65% of you are community interpreters, a lot of federal court interpreters and state court interpreters. So it's a really diverse group, and I'm really glad to be able to be here with all of you today as well. So I'll go ahead and move in. As Marjorie said, I'm a federally certified court interpreter. I'm based in DC from Seattle. So got West Coast proud, but I love it here on the East Coast as well. I have a background in refugee resettlement, and protection, which is how I got interested in immigration interpreting to begin with. And so it's been an interesting journey as both an interpreter and a practitioner, kind of taking on and off those hats over the years.
And Tamber, not
Mhm.
to interrupt you, I just wasn't sure if you're aware that the poll is still showing, and I
Yes,
couldn't
on
get
my
rid of it
screen.
for you.
Yeah,
Thank you.
I had closed it, but I think that it came back somehow. But I will close it. So there's off my screen now, right?
Yes, it is. It's
Okay.
off it's off now. Thank you.
Okay, thank you. All right. So we just did that. And so what we're going to talk about today, I'm going to divide this webinar into a bit about in court and out of court. So within the immigration world, we have our DHS agencies, Department of Homeland Security, who have a lot to do with immigration, particularly one of DHS's daughter agencies, U.S. Citizenship and Immigration Services, or USCIS. And then I'm not going to talk a lot about Immigration and Customs Enforcement and Custom and Border Patrol, CBP, but I did want to say the acronyms at least once because I will say the acronyms constantly throughout. So I wanted to kind of expand those for you. So I'll talk a little bit about what it's like to interpret there and what role those agencies play in immigration. And then I'll talk about the Executive Office for Immigration Review, which is better known as Immigration Court. Or EOIR. And throughout this, because the theme of this webinar series is our remote context, our remote world, I will talk about some of the changes that have taken place for the work that interpreters do in those agencies since the pandemic. So let's talk about what is this Department of Homeland Security. So this is one of the youngest agencies in the US government. It was formed after 9/11. The idea being that one of the great failures of 9/11 was a lack of coordination between intelligence agencies. So the solution that was ideated was this sort of behemoth umbrella organization that brought several different agencies under one roof. And that has been controversial in some ways, successful in others, but overall, it is what it is today, and it's only about 17 years old. And one thing that's important to understand about it is that it is an executive agency. So you can see my infographic here that I created with the White House at the top and the US Department of Homeland Security. And then I've pulled out the 3 immigration-related agencies underneath the Department of Homeland Security. But there are other agencies, like we have FEMA, the Federal Emergency Management Agency, Secret Service, Transportation, the guys that check you at the airport, Transportation Security Agency, Coast Guard. It surprises me every time I realize that, like, the Coast Guard has been an agency, has been a branch of the military without a home for years. It's been part of the Department of Treasury. It's been all over the place, and now it is part of the Department of Homeland Security. So that is why it is so interesting how big this agency is. But for our purposes, we will be focusing just on the immigration aspect of it. But I think what I want you to take away from this slide in particular is that, as we know, there are 3 branches of government in the US, executive, legislative, and judiciary. And this is an executive agency. So it does fall under the control of the president. The president appoints the head of the Department of Homeland Security. So it is part of the political branch, one of the political branches, the executive. So moving on from there, I want to talk about what USCIS is. And I've written here affirmative filings. What that means is that, generally speaking, immigration cases that go to USCIS are cases where people are not in removal proceedings already. I'm going to tell you that there are exceptions, because some people have dual track cases where they have a case with USCIS and a case in immigration court, and those 2 cases may interact. But generally speaking, if you're filing with USCIS, you're not in removal proceedings. You're not facing deportation. So you are asking affirmatively, as opposed to defensively, for an immigration benefit. The types of cases that USCIS processes are vast. You have your family-based petitions, you have your labor petitions, a few different kinds of labor petitions that I've put on the slide for you here, H-1B, I-140. These are processed by USCIS. I think most people know about the family-based ones, where if you apply for a green card through marriage or through a child or a parent, that's usually going to go through USCIS. Naturalization, of course, USCIS. An interesting one that often ends up kind of being processed in many different places at once is special immigrant juvenile status, which is for young people under the age of 21 that have been abandoned or neglected by one or both parents. And if they're here in the US, they can apply for this status. And it's interesting because they often will be in immigration court proceedings to start with. They'll have come over the border alone, and they end up being placed in removal proceedings. So this is one of those exceptions, right, that I talked about. So they'll be placed in removal proceedings at the same time that they're in deportation proceedings in immigration court. They will file it for special immigrant juvenile status. They start in state court, so they have to do something that's entirely out of the immigration system. So they'll start in state court, in family court, and get a custody order, take that to USCIS, get that adjudicated, and then they have to come back to immigration court and get that case, their removal proceedings, terminated. So that one I find especially interesting because of all the jurisdictions that have, or all of the different agencies or courts that have jurisdiction over those SIJS cases. And on top of that, because they are children, they might also have an asylum claim at the same time. So in the case of children, you may actually be in removal proceedings in immigration court, but still get to file affirmatively for asylum with USCIS. So that's one thing that I'm gonna highlight again here, the difference between affirmative and defensive asylum, because a lot of people they get into the immigration interpreting world and aren't quite aware that there are two tracks for asylum, and one is called affirmative, which is the kind when you're usually not in removal proceedings unless you are a child, and you come to the US and you're like, I came here, I got across the border legally somehow, maybe on a tourist visa, but I know that I need asylum, so I'm going to go and apply affirmatively for asylum before I'm in removal proceedings. And that's an affirmative filing. It may also happen that they're here in the US as students or something else, and then their country changes. And so they have a changed circumstances issue, and then they apply for asylum. The other one, which most people I think are much more familiar with, is the immigration court defensive asylum, where you are in removal proceedings, but you say, wait, I have a defense to removal. I am removable, I am illegally here in the US, but I have a defense. And that's the defensive asylum. So that's kind of the difference here. Like, we talk about asylum at USCIS, and we'll talk about asylum in immigration court, but we do distinguish them with this terminology of affirmative versus defensive. Another thing that USCIS does is they will have asylum officers doing the credible fear or reasonable fear interviews at the border. And so one thing to know about that is these are two different things. So when you're interpreting this, you have to realize that you have to interpret credible fear and reasonable fear differently, because they are different thresholds. Credible fear is for someone who's never been removed from the US, and reasonable fear is for someone who's been removed, and then they come and they say, I've been removed before, but I do qualify for asylum, but they have to meet a higher burden. So it has to be probable, like more likely than not, that they will be subjected to persecution back in their home countries. Whereas the credible fear is what it is. Like, they have to have that kind of maybe like a reasonable chance, just a chance of establishing an asylum claim. So it's a much, much lower threshold. And I think, I'm not really sure, I'm sure that there was some sort of policy reason behind doing that, but probably not one that we would, I don't know. I'm not going to comment on that, but it's definitely something to be aware of just from an interpreting perspective. Like, credible fear, reasonable fear, different standards. Therefore, we must use different terms for these. So I will come past USCIS. I'm going to talk about the appeals. So USCIS, if your case is denied, most petitions, if denied, can be appealed. Not all of them, but most of them can be. And one thing that's interesting to know is that USCIS has its own Office of Administrative Appeals, the Administrative Appeals Office. And yet, at the same time, certain petitions, notably, I believe, family-based petitions, are actually reviewed by the Board of Immigration Appeals, which we'll talk about later when we talk about the DOJ and the Executive Office for Immigration Review. Because actually the Board of Immigration Appeals is part of the DOJ, completely separate agency, and is part of the Executive Office for Immigration Review along with Immigration Court. And so it is interesting and worth highlighting that some appeals from USCIS actually go there. And I've drawn two arrows here because I want you to understand that this is dual track. So practitioners can actually make a choice. If their case is denied at USCIS, they just have to look at what type of cases it is, what appeals options they have, and they may actually be able to choose to appeal it, to the AAO, or go straight to federal court under the Administrative Procedures Act, which creates a remedy for it. The Administrative Procedures Act is not just for USCIS. It is also, it's anytime someone has an issue related to an agency, an executive agency, they may have judicial review, depending, underneath the Administrative Procedures Act. So the Administrative Procedures Act is a huge law that is part of our administrative law system in the United States. But it's interesting to know that you don't actually have to exhaust your appeals at USCIS. You can choose to go to federal court. So that's a practitioner decision. Like the Immigration and Nationality Act does not say that you have to exhaust your appeals at the AAO or USCIS level. Once the decision is final, you can go to federal court. And I've put the links down there. Don't worry about copying these or anything. You'll get a PDF of the slides later. So I've just put those in there as sources if you're curious to learn more about USCIS and appeals. So let's talk about where we're at right now with USCIS. So right now, throughout the immigration system, they're trying to proceed with cases, but there's a gigantic backlog because a lot of things have had to be canceled. A lot of the cases have been done where the interpreter is remote. Like I've done a couple of naturalization cases where the applicant and their counsel are at the USCIS office, and they're holding a speakerphone that is usually counsel's speakerphone, and the officer is using that to ask questions. So that can be very challenging for the interpreter because our sound is not great. There's literally a lawyer holding a speakerphone in an office where I presume they're somewhat socially distanced, and you don't see anybody. You just sort of hear voices that are probably about 4 feet away from the phone at any given time. And so that's why I call it hybrid. It's because the interpreter's not there, like one of us is remote. It seems that they don't really want to have applicants, immigration applicants in particular, showing up remotely. So that's why we have this sort of hybrid situation where people are coming in, but they're trying to make it remote for everyone else. One thing that happened within the last month or so, I think things go by so fast, but I believe it was September, was that over the summer, what was happening for asylum interviews where you're required to bring your own interpreter. You're pretty much required to bring your own interpreter no matter what. But for asylum interviews, you would bring an interpreter and everybody would sit in the same office. This is pre-pandemic. Everybody would sit in the same office, counsel, applicant, and the USCIS officer and their computer, and the USCIS officer does the interview. There's an interpreter that is a contractor usually Lionbridge or something like that, on the phone, and that interpreter is the check interpreter. So that interpreter listens to the interpretation and tells the USCIS officer if something goes wrong. They can also be a really valuable resource for the interpreter themselves. So I always make sure when I go in, I'm like, good morning, Mr. Interpreter. Thank you so much for being here. Let me know if anything happens, and I appreciate your support. So it's actually good to kind of establish a rapport with that interpreter. That's normal times. So that what happened shortly after the pandemic was they started setting it up where everybody would be in their own separate office space. So I went to one of these interviews, and there was an office for the USCIS officer, there was an office for me, there was an office for counsel, and there was an office for the applicant and his family. So we were in 4 different offices. So that takes a lot of space, which is why they've had to cancel, I think, a lot of cases. And then we were all linked by video on Microsoft Teams on an iPad. And then for audio, there was a conference call. And so the check interpreter, which still was a thing, was on the phone on the conference line. So if something didn't go right there, they were just on the same conference line as everyone else, and they would just say something, right? Now what has happened is they have just put an end to bringing your own in-person interpreter to an asylum interview. And what they do is they just use the check interpreter. So the contract that they had with the agency providing the check interpreters, now that interpreter just interprets the entire interview. So that's a massive change for USCIS, because for years, it's been one of those things where it's like, well, should the government be providing an interpreter? Is that language access? Or is it language access that they're allowing applicants to bring their own interpreter, but providing a check interpreter? So there's a lot of questions about that, but it's been this way for years. And so for the first time in this pandemic, they're actually providing phone interpreters. So it's sort of one of those things where some people are happy about it and some people are not. Some people had great interpreters that they trusted, and some people were bringing their neighbors. So it's been an interesting development, and I'm sure that we'll all be watching to see what happens moving forward.
Amber.
Yes.
I interrupt as rarely as possible. Mm-hmm. Someone is asking about what USCIS is, and since you mentioned it all the time, if you could remind them that,
sure,
because I'm sure there are other people. Thank you.
U.S. Citizenship and Immigration Services. One thing that I neglected to say before is that most people from a long time ago might be familiar with the INS, the Immigration and Nationality Service. And I meant to say that the INS, the Immigration and Naturalization, oof, wow. I was not an adult when USCIS came into being, so I just know the INS, and now it's escaping me. So they had all of the functions for Immigration and Customs Enforcement, ICE, CBP, Customs and Border Protection, and USCIS, U.S. Citizenship and Immigration Services. All of those functions were under the INS before. And then those split into those 3 agencies that we know today, USCIS, CBP, and ICE. And all of 3 of those agencies became under the Department of Homeland Security. So it's interesting to appreciate how much immigration has changed since 2003 with President Bush's presidency and 9/11 and the Homeland Security Act and the Patriot Act and all of those things that created some massive changes in the way America runs its security apparatus as well as immigration. So, okay, coming back to this, as far as other things that are often related to USCIS, out-of-court attorney prep work, that has changed a lot as well. It used to be that was all done in person, that I would go to law offices or nonprofits and meet with attorneys and their clients. This is the one area that really has gone remote. Like other things, not so much, especially when I start talking about EOIR, it's just like that has not really effectively gone remote. But the attorneys are in my region anyway, in the DC, Maryland, Virginia, we call it affectionately the DMV. they have started to, they've really gotten on board with doing things remote, using Zoom, using WhatsApp. And the one thing that I would really say about this, as interpreters particularly, is that we need to be prepared to help them find technological solutions. It's not necessarily, it's not obviously our role, and it's not, it would actually probably behoove them to figure it out. But the thing is, if we want things done in a way that we know we can provide good interpretation, that we're going to get good sound, that we're going to get a video feed that will help us interpret more accurately, I have found that it works best to take that burden onto myself, learn how to use the technology, and then be prepared to teach it and share it. And so I find myself teaching in the community a lot, teaching providers, teaching when I'm on meetings, helping the people I'm interpreting for, the LEPs or clients, helping them understand the technology, making accommodations. Like, for example, a lot of people have Chromebooks, and because of the way the schools are doing things right now. So all of a sudden they have Chromebooks, and maybe they even have a mobile hotspot at home to access internet, these are great things. Chromebooks, in my experience, produce abysmal sound if not connected to a headset. So it just isn't, by way of an example of a solution provided, is that we muted ourselves on Chromebook. We muted ourselves on the Zoom. We could see each other perfectly, but then we established a conference call on our cell phones. So I got my audio over a cell phone. I have a headset that works with my cell phone, so I actually have pretty good sound both in and out of my cell phone, so that I can interpret accurately, I can hear accurately, I'm hands-free, and everybody feels well served. One thing that I like to emphasize when it comes to remote interpreting is that we try to get everybody in the same space, whether it's virtual space or physical space. We can't really do physical space necessarily now unless you have a giant conference room where everybody can be 6 feet apart. But it's best to not try and do kind of a remote thing where the lawyer and his client are in the conference room, but you're virtual. So it's best to try and have everybody in a virtual space together from an interpreting perspective, or to be present in a socially distanced, safe way. So these are all things that I think interpreters need to consider as they're looking at changes, looking at their technology, looking at their ability to handle it, teach it, be conversant in it, so that when the time comes, when people come to you and say, hey, we need to do this appointment, you can give them some options that meet them where they are. So that's kind of what I wanted to say as far as the out-of-court side of this. And then USCIS, of course, just to recap, is kind of doing things in this sort of unfortunate little hybrid way, where some people are present and some people are not. Okay, so let's talk about the Executive Office for Immigration Review, or EOIR. So EOIR, I just want to say this again, it doesn't just encompass the immigration court, it also encompasses the appeals body, the BIA, or Board of Immigration Appeals. I'll say this again. But when I say EOIR, it's that part of the DOJ writ large. So again, I have this graphic where I show you that it is part of the executive. So you have the White House appoints the Attorney General, the U.S. Attorney General, which then controls the Executive Office for Immigration Review. And so what's interesting about this arrangement is that it gives, because the Executive Office for Immigration Review is very much part of the Department of Justice, it is very much under the control of the Attorney General, and therefore the President has a lot of ability to kind of influence what happens there. So that's just a feature of this court that makes it very different from other courts. And I'll talk about its relationship to the federal judiciary in a moment. But I want to really draw this out, that in the case of EOIR, it is not the same as a state court, it is not the same as a federal court. It is in a completely different branch of government. Because again, if we think back to our 3 branches, executive, legislative, and judiciary, The the judiciary that we normally think of, the federal court system, not the state courts. They're not part of the federal, the tripartite government in the federal government sense. They have their own. But if we think about the federal courts, they're in one branch. And then we have this court. We think of a court, has judges and everything, but it is part of the executive. So that is what I wanted to say about that as far as its basic structure. And again, I want to point out that it is still separate from the Department of Homeland Security and the daughter agencies that we're familiar with, which is Immigration and Customs Enforcement and Customs and Border Protection. So just to kind of give you an idea, because I think I also didn't say this earlier, is that the difference between CBP and ICE is that in general, ICE is meant to be enforcing immigration laws in the interior of the United States. So if you think about a raid on a packing plant, that's ICE, right? And Customs and Border Protection is meant to be doing border security. So when you think about apprehensions at the border, that's CBP. CBP, though, has the authority to operate and do checks, set up checkpoints, and sometimes even search transportation and things like that up to 100 miles from the border, any land or sea border. And so if you think about that, that covers a lot of gigantic US cities, US coastal cities, or US cities in coastal states. So CBP actually comes quite a ways into the interior. So the functions of CBP and ICE sometimes overlap, and when people are apprehended at the border, their case or maybe bounced back and forth. Like they'll start in CBP detention, then they'll go to ICE detention, but all along they'll kind of have interactions with both agencies at the same time. It's confusing, and it would take a long time to kind of figure it out and map it out for you, but just it's worth understanding that these two agencies have separate mandates, but also work very closely together. And then the U.S. Citizenship and Immigration Services also cooperates with them. For example, when someone comes to the border and says, I am afraid and can't go back to my country, and a credible fear or reasonable fear interview needs to be conducted, that's going to be USCIS calling in. So that was always remote. In most cases, if not all, a USCIS officer would be on the phone with an interpreter, and the person would be in a room on a speakerphone answering questions for that interview at the border while they're still in maybe even CBP or ICE detention, depending. Okay, so let's talk about who our parties are in an immigration case in immigration court. So we have the respondent, who I have off to the left here. And they are we refer to them as the respondent. That is the person who is seeking relief from removal. So that's the kind of formal way of saying they are asking not to be removed or deported. We use the word removed because in the 90s, there was a change in the law. Previously, the term was deportation, and there was a change in 1996 with a law called EOIR, Immigration Reform Responsibility, something like that, EOIR. And it created, it merged a couple kind of proceedings into one, which was removal. And deportation became a thing of the past. And so we distinguish it legally because there are still some old deportation cases that exist, and different law applies to those. So from an interpreting perspective, I mean, you'll sometimes still hear judges, because they think people will understand better, saying that people are in deportation or subject to deportation, even though they're actually subject to removal. So you will hear that. And if they use it interchangeably, then you just interpret it that way. But if they say removal, we as interpreters should say a word that corresponds to removal in Spanish, expulsión, as opposed to deportación. So we do distinguish those because they are different. We have the judge, which is a judge in immigration court is appointed in like a competitive application process. So just like any other job in the federal government, the vacancy becomes open, and if you meet the qualifications, you can apply to become an immigration judge. And so you're basically hired, and they are career lawyers within DOJ that are then designated as immigration judges. And then off to the right, I have our Department of Homeland Security lawyer. So those lawyers, this is why it's important to understand that DOJ and DHS are different agencies, because otherwise you would have a DOJ lawyer in immigration court arguing in front of a DOJ immigration judge. So that wouldn't work. So to have at least some semblance of a separation and the idea of a neutral judge, and because, again, ICE is responsible for removals within the interior of the United States, it is logical and reasonable that they are the ones that send their attorneys to basically press for a decision that allows them to do what they see as enforcing their mandate, which is to remove people from the United States, so that are present illegally. So they defend or they prosecute those cases in immigration court. So those are our parties. So what relationship does EOIR have to the federal judiciary? Okay, so we've already talked about how they are separate, how EOIR and the DOJ are completely separate in different branches of government. So first we have the immigration courts. So I'm just basically talking here, where I'm going with this is I'm going into the appeals process. So how does a case get from immigration court to the federal judiciary? Because it does happen quite frequently that cases will start in EOIR, and then through the appeals process, they will end up in the federal judiciary. And so sometimes it's a bit obscure how that happens, so I'm going to try and break it down. So your case will begin in immigration court, being adjudicated by an immigration judge. So that's, like I said, part of EOIR and under the Department of Justice. It's equivalent to what we think of as a trial court or a court of first instance, right? So if you have, if you imagine your three levels, like trial court, appeals court, Supreme Court, that's where immigration court falls, is down at the bottom. They're a trial court. And so they make findings of fact, as opposed to at the appeals level where they tend to make findings of law and they don't look at the facts, like the facts are decided at the trial court level. So the sources of law that we're looking at are US Code, so the Immigration and Nationality Act as incorporated into the US Code, that's Section 8 of the US Code. And then you also, so that's one source of law, and then you have the regulations that interpret that law, which are promulgated by the DOJ in the process of running the immigration court. So you have Title 8 of CFR, Combined Federal Regulations. And so that's two sources of law already. So you have the US Code, you have to look at the regs. And then you also have case law or jurisprudence from the Board of Immigration Appeals, and also from federal circuit courts, and also from the Supreme Court. So that's a lot of law that an immigration practitioner needs to consider as they are moving forward with their case. If you lose your case at the immigration court level, then you can appeal to the Board of Immigration Appeals. Either side can. So Department of Homeland Security can appeal, as well as the respondent immigrant can appeal to the Board of Immigration Appeals if they lose that case. So it's also part of EOIR and under the DOJ. Sometimes they publish decisions which become precedential decisions, and those are meant to establish law that the immigration judges must follow. So if the BIA puts out a published case, that becomes a precedent case, and that means that whatever the BIA said about the law in that case, unless and until it's overturned by the federal circuit court, or unless and until the BIA reverses it or a new attorney general comes and invalidates it, that law that is established by the BIA in that published case is binding on all of the immigration courts in the entire country. So regardless of whether or not you have, regardless of what circuit you're in, if there's a BIA decision, that is binding on your immigration judge. So here's where I wanted to introduce a poll as far as when cases move out of the administrative system, out of the DOJ and into the federal circuit court. So this is just a quick test your knowledge just to see. And the question, once we get the poll up, is who do you think can appeal to federal circuit court. I don't know if I just can't see the poll, or since we screen shared in kind of a unique way today.
Tamber, we are experiencing some technical difficulties that we're working to resolve. The poll is showing to me. Can you see it?
I can't, but if people are answering it, then it's fine.
Yes. Right now we're showing, oh, this is, I'm sorry, this is actually the poll, poll number 1.
It's, actually, don't worry about Marjorie. It actually doesn't matter. It's just a kind of a fun quiz to see what people think. But because this was actually something that surprised me recently, because I continually learn about immigration law, and I'm continually finding little gaps in my knowledge because, as I've just described, it's incredibly complicated. So the actual reality is only the respondent immigrant can apply, can petition for appeal to the Federal Circuit Court. So if the Board of Immigration Appeals rejects the case, then the respondent immigrant can apply or request it, can submit an appeal to the federal court. But DHS cannot do that. So if the Board of Immigration Appeals grants the case for the respondent immigrant, that's curtains for the government's case. So they cannot appeal beyond that. And so in federal circuit court, what's interesting that you'll see is that totally different lawyers are prosecuting or are defending in that case. It's actually more of a defense because you're appealing against the DOJ's decisions. The DOJ has made a decision. That's the immigration judge representing the DOJ has made a decision and the BIA has upheld it. And then you go to federal court, you skip the trial court level completely. You do not go to a federal trial court, you go straight into the Court of Appeals. And there you will be met by AUSAs, so Assistant U.S. Attorneys from the Department of Justice, from the Office of Immigration Litigation, OIL. And so they will be defending the decision of the Department of Justice in the circuit court. And as far as law there, the circuit court will find decisions from the BIA persuasive and may actually by law need to defer to them in certain cases because of something that we call deference or Chevron deference. There's a couple different kinds of deference in administrative law. So administrative law gets very complex. But suffice it to say that basically there's a principle of law, sometimes referred to as Chevron deference, and then there are other types of deference, but mostly we talk about Chevron deference, that requires the federal courts to give a certain amount of leeway to the administrative agencies whose cases come before them. Like the administrative agencies were given authority by Congress to interpret the law if their interpretation of the law is a reasonable one, to put it simply, this is a simple way of putting it, if it's a reasonable one, a rational interpretation, then the judges at the Federal Circuit Court pretty much have to leave it alone. But not necessarily. So sometimes they can overrule it if they consider that it's not what Congress intended, that what the agency decided is not what Congress intended that agency to be doing with the law. And so the federal circuit courts will be looking at law just in their circuit. So there are 11 circuits in the US plus the DC circuit and the federal circuit, so 13 total, but the DC circuit and the federal circuit don't have anything to do, well, they have some things to do with immigration, but they don't really hear cases coming from the immigration courts from EOIR in the same way. So mostly we're looking at the 11 geographical circuits. And they will look at the case law primarily in their own circuit, but they may look outward. If they don't have a case on point in their jurisdiction, they may look out to other circuits and make decisions that way. So that's why if you've heard and found it a little confusing or a little interesting, why someone says, oh, well, it's better to be in the 9th Circuit as opposed to the 5th Circuit or the 11th Circuit or whatever circuit, that's why, because the law may be different in that circuit because those judges and those courts get to make the law for their circuits. Now, sometimes, rarely, the Supreme Court will agree to hear an appeal of a case from a federal court. And that's, I mean, when I say rarely, I mean that it's not just that it happens rarely for immigration, it happens rarely in general. Only a small minority of cases that are appealed to the Supreme Court are actually heard. But if there's, for example, a significant conflict between the circuits, like I just said, the law in the circuits can be very different, but if it's so substantial that it becomes an issue of justice, the Supreme Court will pick an example case that really is a very good example of that conflict, and they will hear that case and decide it so they can kind of fix that circuit split across the country. Or if the case presents kind of a new question, we call it a novel question of constitutional law or federal law, then the Supreme Court might also agree to hear that case. So that's kind of how that works. So just to recap, the way cases get from the EOIR into the federal court system is by petitioning for appeal, and only the respondent immigrant can do that. And that has to be after the case is final. And you'd be surprised at how complicated final can be when it comes to BIA and immigration decisions. But just so you know, the immigration case must be final before it can be appealed to the federal court. So how do they get to immigration court even to begin with? How does that start? So we have to go back to our DHS agencies, and all three of those agencies, if they find that an immigrant is in the United States illegally without a proper remedy, they may issue a notice to appear that then vests jurisdiction in the immigration court, that creates the authority for the immigration court to make a decision about that case. So a notice to appear, now the reason why I bring this up is because a notice to appear is very much like a charging document. It's like an indictment. It's like information. It's a combination, subpoena or citation and charging document in one. So it both tells you have to go, you're being notified of the case, you're being told you must appear, and it's telling you at the same time what the charges are. So immigration charges. So that is how cases get initiated in immigration court. It's analogous to what happens in state and federal court, because you do have, an agency, the prosecutor, that brings charges, and that's how a case kind of begins in regular court. And so it's useful, I think, to compare that, but then also to recognize what the differences are, because that is your first notification that you have a case, is this notice to appear. So you're being told where and when to come, which charging document typically doesn't do. And you're also being told what the charges are. As with an indictment in criminal court, these documents must have form, and defects in the charges can result in problems with the jurisdiction of the immigration court, as we found out a couple years ago in a case called Pereira versus Sessions, where we found out that if there is a defect in the form according to the statute that says how cases get vested in the immigration court and how the notice to appear must be written, if there are defects, that can have effects on the immigration case. So Pereira versus Sessions was a really interesting one about cancellation of removal, if you're interested in that. So I put it down there so you can look it up later. And this is going to be probably pretty small on some of your screens, so don't worry, you'll get this as a handout. This is an example of a notice to appear. And when you get a chance to really look at it, I want you to notice that it is defective. So at the very bottom, it says on a date, so it says you must appear, you are ordered to appear before an immigration judge at the United States Department of Justice on a date to be set at a time to be set. And that is defective because the statute requires it to say when and where. And this one doesn't. So this kind of a notice to appear is very, very common, was very, very common. And it was challenged because it is defective in that case, Pereira versus Sessions. So a little piece of history right here for you that you will have. But you can also use it as an example to see what it actually looks like. Because a lot of immigration interpreters don't see one for months. They may never actually see one. They'll just hear it referred to. It'll be over there on the judge's desk and they never get to look at it. So this is what one looks like. So you'll get a copy of this. What are the most common charges on NTAs? And I wanted to show you this because a lot of people think that you end up in immigration court because you committed a crime. And that's not necessarily true. So yeah, I went to track at .syr.edu, that's Syracuse University in New York, and they do a really nice job of compiling immigration data. So you can find out anything you want just about statistics within the immigration court, nationalities, charges, grants and denials. You can find grant and denial rates by judges. So you can find out, you can look at it and be like, oh, wow, I'm appearing before a judge that has a 99% denial rate. That's really true. That does happen. Or I'm appearing before a judge that has a 70% grant rate. So it's interesting to look at that data because it reveals some of the disparities within the immigration system, some of the things that vary across judge and across court. Because you'll notice when you look at that you'll sometimes actually the judges, some whole courts have much lower grant rates than other ones. But with regard to this specifically, you can see that entry without inspection and some other immigration charge, like maybe an overstay or something else, these are often the reasons why people end up in immigration court, as opposed to 13.7%, which are criminal charges. One thing that you should know about this, though, is that often people do come to the attention of immigration via the criminal justice system, usually often some minor thing, but then they end up in immigration court. And the crime they committed may not be a crime that leads to removal, like we've heard when people are, oh, I got pulled over for not wearing a bike helmet and then I ended up deported. Well, they didn't get deported for not wearing a bike helmet because that is not a deportable or removable offense. But they did end up within the gaze of the immigration system because they ended up in a justice system and they ended up in a court that probably cooperated with ICE, or a police system that probably cooperated with ICE, and then ended up in immigration court. But the only actual charge that could be brought against them was an immigration charge, because you can't get deported for small stuff like that. But you can come to the attention of immigration because of small stuff like that. So there may be criminal charges behind some of these non-criminal immigration charges, just to be aware of what those statistics truly reflect. But in general, people are not being deported because of criminal charges. Usually those are going to be people who are already in the US, probably with permanent residency or something like that, some legal status, and then they committed a crime that made them removable, that would effectively cancel out their status. And that's when you see these cases that are predicated or founded on criminal charges. So how do cases move through court? So we start with a master calendar hearing, which is kind of like an arraignment or a preliminary hearing. But in immigration court, we have to understand too that a master calendar hearing, although it is most often similar to a preliminary hearing or an arraignment where you get your charges read to you and your rights read to you, that's your first one. A master calendar hearing can also be where motions practice happens, where people make motions and get rulings, sometimes very quickly, often very quickly, because these dockets are quite long. They're usually, they may be 10 people, but they may also be 60 people. So often they're kind of like a court mill, basically. Like you just come in and out, the judge says the same things to everyone and then sets you a new date. But a lot of different things can happen at a master calendar hearing. There are other types of hearings that may come after that or in between master calendar hearings. You may have bond hearings if you're detained. So that's your chance to argue to the immigration judge why you should be released on bond. You may have a competency hearing if someone identifies that you may not be able to fully understand your immigration process. You may contest your removability to begin with. Like you may say, you think that the crime that I committed makes me removable, but it doesn't. And then you will go and you'll argue why. There will be testimony why, and both sides will make arguments and the judge will decide whether or not you are in fact removable and a case can proceed against you. So that one's actually the one that's most like a preliminary hearing or a probable cause hearing. And then after all of that, you will come to your individual merits hearing, sometimes years later. And that's like the trial. That's your immigration trial, where you have arguments, presentation of evidence, and then at the end, you can reserve appeal if you don't like the outcome. And you have 30 days for that to take that to the BIA. So that's the progress of cases through immigration court. Respondents do have rights in immigration court, many of the key constitutional rights, they do have a right to due process. And so they can present witnesses, they can question witnesses, they have the right to know what they're accused of, so they have to be informed on what basis, on what charges they're being, the proceedings are being brought against them. They do have a right to a qualified interpreter that is enshrined in the regulations and statute if they do not speak English. They do not, however, unlike in criminal cases, a lot of people argue that there's just as much at stake in an immigration case, but they don't have a right to a free government appointed attorney. So they don't have a right to a public defender. And this is not the same in all countries. So in other countries, immigration cases do, immigration systems do pay lawyers, do appoint lawyers. But here in the US, we have the right to hire our own lawyer, a lawyer of our choice, and the court has to give you a reasonable amount of time to find an attorney. So often that first master calendar hearing is just a continuance. You go and you say, I'd like time to find a lawyer, and the judge will give you sometimes as little as 2 weeks, sometimes as much as a year to find an attorney to represent you. So you have that right to representation, but you must procure it on your own. So those are kind of the key rights of respondents in immigration court. Current operating status of EOIR. So most courts are now open for non-detained and detained individual hearings. At the beginning of the pandemic, they were completely closed for all except detained hearings. And so judges would go in and they would meet with the respondent over video from the detention center. And so only detained hearings were going forward. As of, I believe it was about July or so, that they started opening the courts for non-detained hearings and individual hearings, still not master calendar hearings. And those have been kind of back and forth because there are frequent closures in the immigration court, like the DOJ will just tweet that X court is closed. And often it's because of a COVID case that may have come up in that court. So it's a little bit of a kind of like, oh, will it or won't it go forward for immigration practitioners, respondents, and interpreters. So, but right now what they're doing is they're having everybody go. It is all in person. There are masks and social distancing. Some judges allow the interpreters to just use a face shield if they're sufficiently distant from everybody else in the courtroom. But pretty much everybody is usually masked and you're 6 feet apart. This is challenging. I've been told by interpreters that it is difficult. I haven't actually been back to immigration court. So I will disclose that I haven't been back to immigration court since March because of the pandemic. So I've only observed, but I've been told that immigration interpreters do find it a bit hard sometimes to interpret through masks and also to hear people. And so it's become more important than ever to have your court protocols down really well so that, you know, when you ask for repetitions more often now than you used to, it's, you know, very smooth. It's like the interpreter would like to request a repetition, blah, 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 can you repeat? So this happens more than it used to. The government counsel almost always calls in. So the respondent's counsel usually is in person. Sometimes they call in as well. The respondent pretty much always goes. And so respondent's counsel will be there at the table, but government counsel will be over the phone. So that's an interesting thing that's totally unusual because you just hear their voice and they have an empty table over there. So throughout the whole hearing, it almost feels like they're not there until suddenly there's an objection or something like that. There are huge backlog issues related to this. And in fact, the National Association of Immigration Judges issued a call for remote virtual hearings, and they renewed that call, I think it was September 23rd, so really recently. They put out a white paper comparing the implementation of remote in immigration courts to the implementation of remote in state and federal courts, and found it wanting. And they said, you know, our sister courts are doing this, why aren't we? So if you're interested in that, that's also going to be one of your handouts. I am sending along that white paper just so you can see what this what the Immigration Judges Association is saying about remote in the courts, because it is true that the courts really just haven't implemented remote in a serious way, the way that other courts have, for different reasons. And I'm not really privy to all of the reasoning and all of the thinking, behind it, but it is true that it is quite different to how it has gone in state courts and federal courts since the beginning of the pandemic. Things to be aware of in immigration court. The first thing that everybody notices is that interpreters are not in teams. So we work alone, which has implications for how we do our work. We will do a lot of it can be difficult when things get long. So a lot of the cases though are pretty short, and so it's a little bit more manageable than you might expect, with only like 30 minutes of simul here, and then maybe 45 minutes of testimony, and then a break, and then another 45 minutes of testimony, and then another 30 to 45 minutes of simultaneous. That's pretty typical, I would say. So it's not an exaggerated situation. Although I certainly have done cases where I did end up doing simul for an hour or more alone, which is not best practice and not ideal. So we'll talk a little bit about how to mitigate that. You're always recorded. You're on the record all the time. We don't do a lot of sight translation. We're mostly simultaneous and consecutive. And the pace is fast and the terminology is specialized. So as immigration interpreters, we need to be ready for all of those things. Like more so than in the state courts, like the pace is really, really fast and the terminology is very specific. And sometimes the terminology, the same words mean different things in immigration court to what they mean in state court. So how to mitigate that? So first of all, talking about terminology, it's extremely important to be able to follow and interpret accurately, to have at least a basic familiarity with immigration law. And to be aware also that some legal terms are, like I was saying just a moment ago, are used differently in immigration court. Like a frivolous claim, for example, in regular legal terminology, that just means a claim that has no merit, no basis in the law, right? But in immigration court, they ratcheted it up quite a bit. So a frivolous claim in immigration court isn't just one that has no merit. It is a particular finding that relates to when you say something, when you actually submit a fraudulent claim. So if you submit a frivolous asylum claim, that means you actually lied on the application, and then you're barred forever from receiving immigration benefits. So it's really important to take that into account when interpreting. Like I don't use the same interpretation for frivolous in immigration court as I do when I interpret in state court. Parole is another one. Like to be paroled into the US is to be admitted conditionally. And so my interpretation reflects that. It's not like a temporary liberty the way being released from jail is temporarily. So these are just some examples to be aware of. And so the way to know that is to look at the law and know the statutes. Coping with immigration court, the pace and the fatigue. So you have to be assertive with your breaks. And this is something that's really clutch, is that the immigration court has a bench book for judges. Most courts do have bench books, which just pretty much is what the judges have to say frequently over and over again. And so there's an asylum boilerplate, there's the cancellation of removal boilerplate. And what I've done is I've created exercises for myself using those. And one of the resources you'll get today in the next slide, actually, which I won't talk about a lot because it's mostly for you to have later, is where I've created some exercises, some examples of those exercises based on the bench book on my website, where you can go and just download them for free. It's just for you to use to give you an example of how to do it. And then I've curated the bench book as well, so that you can find quickly the ones that are going to be most useful to you in practicing to be ready. So when you're doing that really fast, really long simultaneous, the cognitive load is less because you've already basically memorized it. You know the terms, you know what you're hearing, so that you're ready to just interpret. And for me, I find that makes a big difference in the quality of my interpretation, my ability to handle longer stretches alone, and also just how fast it goes. I'm not advocating for that to stay that way. I think that we should be working in teams, and working in teams is the best way to interpret. But the fact is that it's not that way in immigration court, and somebody's got to do it, and you might as well do it really well. And so this is kind of how, like, we basically just have to do a lot of prep work and a lot of self-familiarization. I'm going to skip the part about protocol. It's very similar, just a little stricter. These are your resources. And these are the books that I will recommend to you. Here's some links here that you can use. Like I said, I have now curated this is where I got it from. This guy, I think his first name is Matthew Hopbuck, and he actually was kind of tilting at windmills trying to get the immigration bench book used to be freely available on the DOJ website, but they took down the newest version a few years back, and he was using FOIA, Freedom of Information Act requests, to get it, and he was getting it back in pieces and posting it on his website. So I drew from that, and so, you know, thanks forever to him. I follow him on Twitter too. He's very interesting for doing that. So thanks so much to him for doing that, because as interpreters, we can draw on that as a resource. There's a glossary here, and I also, again, really recommend this book, which is written for practitioners. It's written for lay people practically. It's not super lawyerly, but it goes through all the cases. So when you hear a case, you'll know what it stands for. So I really like this book. If you're going to do an asylum case, you just flip open a couple hours of reading, and you're very familiar with asylum. So I highly recommend that. Why do this work? You know, I'm not selling it to you, right? Like, I'm like, it's hard, it's fast, you're alone. But it is sort of a proving ground. You will, if you work hard at it, your skills will improve dramatically and quickly, just in general, as far as being an interpreter. I find it rewarding. I find it interesting to be part of something that's very much part of the national conversation. I like to be privy to that. It's an interesting place to work, and I think that it is compelling work, and it's a strong public service work. To be there, to be a good interpreter in immigration court, to work hard, to be that voice it's very rewarding public service. So I encourage interpreters to go there. Because you will learn a lot. Your language skills will massively improve, just because you will be exposed. Most languages have dialects from a lot of different regions, and you will be exposed to all of those dialects, all different socioeconomic levels. So I've learned a lot about Spanish across the Spanish-speaking world because I'm in immigration court, hearing the way people talk about their homes. You know, and when people talk about their homes, they use the words that they're familiar with. So you hear a lot of that. It can be daunting sometimes, because you're like, just what does that even mean? But you also learn at the same time. So these are the reasons why I really like it, even though it can be challenging in many ways. But I really would encourage you to try it. It's a lot of fun. And you can try USCIS first. So it's a little bit of you can ease yourself in, get familiar with immigration in a less sort of pressured environment. And then if you like it, if it's right for you, then you can consider moving into immigration court. So now I can turn it over to Marjorie I can stop my share, and we can start talking questions. These again are just links for sources that you'll get when you get the PDF. So should I stop my share, Marjorie?
Sorry, just had to unmute myself. By all means, it's very nice to see there. It is so nice to see you live and full screen. There are, of course, a million questions. There always are, and you, I think, perhaps more than most. So let me not waste time. And first, I should mention that I may be asking questions that you've answered. I had such technical difficulties that I had to devise a way of shutting down the computer, which froze completely, and not close down the webinar. And the second poll disappeared. Some questions may have, but I fortunately copied and pasted them and color-coded them into a Word file, so I got those back. But if I ask you something that you have answered during
No worries.
that would be the reason. There were several questions. There seems to be some confusion about needing to be court certified to interpret. I imagine you probably addressed this at some point, but
I didn't actually. That's a really good question. So I'm glad that's the first one. So immigration court does not have a certification. There's no certification to work in immigration court. Immigration court, the EOIR is always contracted with private companies to provide interpretation. So over the years, it's been Lionbridge, it's been Berlitz, it's been something else that I can't remember, and it's been SOCI, which currently has the contract, and their contract was recently renewed. So they will continue to hold the contract for the foreseeable future. And what they do is they vet and train the interpreters, and you will be subjected to, that makes it sound bad. I think it's really actually good. I think it's great. So not subjected to, you will have to undertake a testing process. So you'll be first screened for basic interpretation skills and language proficiency through an interpreting test. And then you go through training, which does a pretty decent job of familiarizing you with what happens in immigration court. So I do recommend, taking it seriously and going through it with commitment when you do it, because it is meant to take 3 weeks. And it's all online and self-directed. And if you take it seriously, you'll pass at the end. Because it does have some great labs. Like, they actually give you practice materials that are realistic, that you can work with to get ready for the final test, which is more difficult and faster paced than the initial screening test that they run you through just to see if you have the basic skills to be able to try it. But it is not a certification. So it is just the private agency, SOCI. They are the ones that are basically qualifying you. So you are a qualified interpreter. But it still does help to be court certified very much. And I highly encourage it for interpreters, because even though it's not required for you to be court certified to work in immigration court for SOCI, the act of becoming certified shows your dedication to the profession. And it also, because it requires so much study and effort, and also requires you to kind of get in contact with norms of the profession and all of that, it makes you a better interpreter. Like, even if you fail the test, you're a better interpreter at the end of it because you worked to study. So I do encourage it, but there is no certification. You don't have to be certified to work there.
Well, thank you, Tamber, because you just answered another question, which is, how do you become an immigration interpreter? So that was convenient.
Yes, apply to the agency that has the contract, which is SOCI.
which currently is SOCI. This person says, I'm not a USCIS contract interpreter. USCIS asked a client to prepare an interpreter, me, and the USCIS officer called me as the client provided interpreter. Is this something we can expect to happen regularly? And I think we can guess the answer from some of the things you were reporting that are recent events.
Yes, because it used to be that I haven't been where the USCIS officer called me, but it doesn't surprise me at all. It's just that in my cases, it's always been the lawyer that had the contact with me, and the lawyer then just called me on their phone. But I wouldn't be surprised to have it, and would probably prefer it, because I'm sure that the USCIS desk officer's phone is probably better than the attorney's speakerphone. So I don't know, like, different officers and different offices are going to do different things, but it is true that interpreters are appearing a lot via phone these days.
Speaking of which, can Tamber please share what model of headphones are compatible with cell phones?
Okay, so it depends on what your connection is. So for an iPhone, huge pain, right? We only have this Lightning connector, and so I connect a 3.5 millimeter, like this Sennheiser headset. It's a nice gaming headset, and it has a 3.5 millimeter jack connection. I'm going to try and, somewhere on the floor here, is the other end of this. This is what a 3.5 millimeter jack is, if you're not familiar. And then I connect that to the adapter, and that goes into my iPhone. But Androids are a little bit easier, because they may have a 3.5 millimeter jack already, or they might have a USB-C, which I can also show you, which is this little guy. So they have this is the plug for some Androids, a lot of Androids actually. And so you can connect a headset that's a little more sophisticated to your phone using that USB-C connection. And if you have a USB headset, and your phone has a USB-C connection, then you can buy adapters. Like, I have a Mac, and so this is actually what I was even showing you, was actually an adapter. So this connects to another headset that I sometimes use, which is a USB headset, but because I have a Mac that only has USB-C ports, I use an adapter. So you could get that for your phone, I assume, as well.
And we also, thank you, Tamara. I had questions, a few questions about your microphone.
Okay. So right now what I'm using is what I use for presenting, which is a gooseneck microphone. And I started using these, and I told Marjorie I was going to do this, that one of the things that, again, about solutions, right? When we need to find people solutions, this applies more to kind of conference and webinars, that kind of work, than it applies necessarily to court. But one of the things that I've been doing is actually quoting in, sending presenters headsets, or not headsets, mics, these mics. Because any of you who are conference interpreters in this day and age with RSI, remote simultaneous interpreting, and you're wearing those headsets and you're hearing just a great variety of sound, and it's quite terrible. So what I'm trying to do now is actually send presenters, uh, just quote that in. So it's like $35 for a gooseneck mic like this, and just send it with them. But that said, this particular one is a Junevo. This one, it's actually quite, you can't hear me as well right now, but it's actually quite cheap. I think this one was actually under $35. The one I truly recommend, and I'm going to put it in the chat, is not with me right now. It's in another space, but it's the Fifine gooseneck microphone. You can find it on Amazon. It fluctuates between $29.99 and $35. But that one is really, really good and gives you an impressive quality sound for under $30. So if you're an interpreter on a budget and you actually prefer to have a separate mic headset, and you have a very quiet space, like you don't want this mic for different reasons, like you prefer this kind of thing, it's good enough. Like, it actually is good enough for interpreters, even though I generally kind of err on the side of spending more money for more reliability, perhaps long term, I'm not sure, as an interpreter. But the Fifine gooseneck, not the mini, but the big one, the gooseneck, the mini is not good. I bought that one too and I didn't like it, but the big one that you'll see for about $30 on Amazon is a really, really good choice for presenters and for you.
Okay, thank you. Now a nice short one. So is this test for immigration interpreting language neutral?
It is not language neutral.
And oh gosh, it's hard to choose. How do you cope with the emotional drain of interpreting for cases that is more likely than not to have a negative outcome for the respondents, and at such a high rate?
That's a good question. And it's something that I struggled with a lot. I still struggle with it, but less over time. Because I actually, for the first 6 months or so, it was a constant stress ball for me to be in immigration court. Like, I just felt like my job was too important, and any little slip up could lead to somebody's life being incredibly changed for the negative. And it worried me a lot. And I spent, like, I was just like a ball of nerves every single day. But like with most things, therapy helps. And I had a therapist who was also a lawyer, and she told me, listen, it's not all on you. It's not all on you. There's a lot of other checks in the system. The attorney's there, the judge is there. It really isn't, it doesn't all weigh on you as the interpreter. And that helped me a lot. I'm not sure if that answers the question, because I think the question was just in general, how do you deal with the sadness of the cases? And I think that the most important thing is just to have kind of your own center, your own place of peace, and the people that support you. It's always important to have people around you that understand you and that listen to you. So I think that's really how to cope with it. But in my case, mine was a little bit more complicated, because I had this performance anxiety, as well as like really caring a lot about doing my proper, neutral interpreter job. I'm not biased one way or the other, but like just doing the correct job, like making sure that the questions are asked right and the answers are given correctly. I found that so anxiety inducing because of the stakes of the case and because of the frequent outcomes. But number one, knowing that it's not all on me, and number two, having people around me that supported me, other interpreters particularly, cultivate those professional connections, because you'll find that you're not alone.
That is great advice, Tamara. I would just add to it, there's a lot more self-care, free resources and training out there on the internet. And self-care for interpreters is something that's good in every area of interpreting, and will certainly help you in this one. Here's a question. it's interesting, for due process in immigration court, when you say right to a qualified interpreter, does that mean a court-provided professional interpreter?
Yes, it does. Yes, it does.
Yay.
So over the years, things have, I think, gotten a lot better in immigration court in terms of the skills of the interpreters who provide services there, and the vetting of those interpreters, the vetting and training of those interpreters. It's, you know, a slow process, iterations over decades. But Marjorie, I just lost track of the question.
For due process in immigration
court. Oh, due process, qualified interpreter, yes. Yes, it does mean a professional, and it does mean a qualified interpreter. It doesn't particularly, if I recall, it doesn't really spell out what that means. It just says qualified interpreter, and that's been taken to mean that, you know, someone that's court provided. You never see like family members and interpreting for individual cases. Every now and again, a judge will lean on a little bit for a rare language for a short hearing. I've seen them just say, oh, can you just tell her to come back at this time? And it's a decision that the judge makes. But generally speaking, it is a professional interpreter paid for by the court.
Thank you. Another interesting one. In a remote interpretation context, a USCIS officer asked me to fax a copy of my ID for his file. I asked if I could send it to him by email. He said no. I suggested I could send a picture of it to the client's phone. The officer said no. So the question is, if I do not fax my ID, will my action have an impact on the final decision? Wow.
Ooh, I mean, I would doubt it, but I don't know. I don't know the answer to that question. That's a good remote question, because you go to USCIS and they take everyone's ID. But that sounds awfully difficult to be like, you must fax it. Yes, I will fax this back to 1980 for you. And that's a lot of work. But yeah, I don't know the answer to your question, I'm afraid, but I would tend to think no. But you just never know with USCIS. You just don't know.
And to clarify for our listeners, fax is recently something I've had to deal with a few times, and I'm going, what? We don't fax anything anymore by fax machines. But it is emerging for both government agencies and occasionally banks and things as a security requirement, but especially government. It's a very strange phenomenon to be going back to the 80s.
And you can do it online though. Like when if I have to fax stuff now, I actually just have an account. I can't even remember where it is now. I usually just have to open a new one because it happens like once a year that I have to do this. But you can fax it over the internet, and that's the solution. That's what I would recommend. It's a little bit of a pain, but it's not as much of a pain as going down to a Kinko's or something like that and faxing it.
Thanks. Are there PDFs of the boilerplates that the judges use available to us so that we can prepare and practice for our first time in immigration court? Great question.
Great question. And yes, and you have links to them in my slides. So what I linked you to the lawyer's site where I got a lot of them, but then on my own site, which is also there, I have curated it. So I found the ones that are most useful to immigration interpreters and posted those PDFs on my website, as well as give you an example or two of how you can adapt those exercises, or sorry, adapt those boilerplates into exercises. So like basically I take the language, write a little bit of a story to go with it, and then record it in English, and then use that for simultaneous practice. And I've done that with one of them, and you can find it on my website for you to use and then draw up your own. And somebody's just put in the chat what the address is. It's on the slides, but I will type it here too.
And any word on when immigration court might make the switch to team interpreting? I told the recruiter, says this interpreter, that that's a deal breaker for me.
Yeah, no word. That is going to be that, and that's a long game, and it's a decision that EOIR would have to make. It's not the contracting agency, it's EOIR. So that may be very far in the future. Who knows?
Yeah, that does not sound good. Do you have a short list anywhere of where terminology differs between courts beyond the ones you mentioned, like frivolous and paroled? This person says that would be an awesome resource.
I don't have a list. That is a list of the most common one. The one that's on the slide is the list of the most common places where it differs. I haven't run into just an extreme amount of difference. So the lucky thing is that a lot of it is the same, but because those particular terms like parole and frivolous are so common, you would really want to make sure that you look in your language for words that reflect them. And we also don't refer to the government attorney as a prosecutor in where we're used to in the state courts, in regular courts, we're used to saying la fiscalía whenever they say government, and that basically just means prosecutor in Spanish, or the office of the prosecution. Well, we don't call them that in immigration court. We just call them the government attorney or the DHS attorney.
Great. We're having a number of questions, or a few questions, not many, that relate to, you know, getting into the field and suggestions for immigration agencies, and what do you mean by SOCI has the contract? So is it, first, you might want to explain how SOCI got that contract and what that means, but also, I mean, is this the only way that you can get on board, or are there other agencies that you can get work through?
There's only one agency at any given time. So like just to kind of recap, EOIR has pretty much always hired its interpreters through different private agencies. And it's a competitive bidding process like any government contract. And so what they do is at certain times, they open it for bids. And then language agencies will submit their proposals. And then the EOIR will select from those proposals, and that is the agency that will have the contract for however long, usually about 4 years or something like that. And then it can be renewed, or another agency might take over. So that's how we've gotten, Lionbridge, that's how we've got Berlitz, that's how we've got SOCI now. So SOCI is the current holder of that contract. They won the bid some years back, and like I said, it's recently been renewed. Oh, yeah, there's no other, the only other way to work for immigration court would be as staff, or the immigration court does contract remote interpreters for often languages other than Spanish, or when an on-site interpreter isn't available or it's just not necessary for like really short hearings. So there are other agencies that have contracts to do the phone interpreting, like Lionbridge, like LSA, maybe even Language Line. I'm not entirely sure who. I know it's multiple companies that have contract for the phone interpreting.
And obviously for attorneys who do immigration, when it's just the client and attorney, then it would be every way that you normally get work for attorneys, right?
That's correct.
To interpret for attorneys, I mean.
To interpret for attorneys, yeah. So it might be through your local language agency. It might be through a large language agency. It might be through a nonprofit.
Mm-hmm. Yeah, all kinds of ways that you end up interpreting for attorneys, for sure.
But I recommend that you start with that, like before you jump into immigration court.
Yeah.
Work with the attorneys, help you learn the law. If you have a law school in your area,
mm-hmm.
I found it really, really helpful. Like before I really started interpreting in immigration court the second time around, like I've had 2 iterations of my interpreting career. But I was kind of out of practice for about 6 years. And so when I started up again, I just wasn't comfortable, wasn't ready. And I volunteered for Georgetown Law, which is incidentally where I go to school, but you don't actually have to be a student there to volunteer. So you can see if a local law clinic needs volunteers to help them interpret their immigration cases. You will learn so much, and the students, they're also learning at the same time, so they're happy to share their knowledge.
Sounds like a fabulous idea, a win-win. Highly recommended that strategy. One last question. Generally speaking, are the judges unfriendly toward the interpreters?
I haven't found that. I have not found that. Judges appreciate, in general, the interpreters. Sometimes they're busy and impatient, and I've heard stories. But in my personal experience, I've had great experiences overall with the immigration judges. I don't find them unfriendly. I only interpret in Arlington, though, so.
Yeah, so in your experience, actually, so we do have to, I just want to ask this one last one because it's so quick. Who has the final decision or say, EOIR or federal court?
Well, it depends on how far you go. So if you wait past the 30 days to appeal, you have a solid right of appeal. You have a solid right of appeal. You wait 30 days. If you wait past the 30 days to appeal to the BIA, then you lose your right to appeal any further, and you're stuck with the decision of the immigration judge. There's also a period of time to apply for or to submit your appeal to federal court, and I want to say it's a similar time frame, but I also don't want to be wrong because it's not at the top of my head. But again, if you wait past that time frame, you won't be able to appeal to federal court either. But I guess you could say that the federal court has the final say, but often the federal court will simply remand the case, send the case back down, and then they'll just say, here, you did this wrong, fix this, and then it's good. And then it may get appealed again. So it kind of goes back and forth, but you could say that federal court kind of has the final say.
There, I thought it was going to be a simple, quick answer. We are 1 minute past, so I want to thank you, Tamber, for a hugely informative presentation. And again, we had so many requests for this one, and I know that the recording will be well viewed as well as this live session. As always, I will stay on after we liberate you now, so that I can answer questions about anything from certificates to plans for other, et cetera, et cetera. But the bottom line is we will let you free now. You must be tired. That was a lot that you very, very generously shared with the whole audience. And we are deeply grateful to you, Tamber. And if we get any questions that we can't answer, we might punt them on to you.
All right.
Thanks.
Thank you so much. Have a great day, everyone, and thank you for coming. Good luck to you all, and really good luck. Like, go out there and do the good work.
Thank you, Tamber.